I'm Paul Harmer, the Technical Director for the CIPHE. I'd like to welcome you today to this Smart Talk Live in conjunction with Ems Gilmore Libison Solicitors, focusing on the legal aspect of the plumbing and heating industry. Well, welcome today to this inaugural event. It's the very first Smart Talk Live on law, and today it's been held at Ems Gilmore Libison Solicitors in Birmingham. First and foremost, I'd like to introduce Sarah Bingham.
Hello, my name's Sarah Bingham. I'm a commercial litigator specialising in health and safety matters and trading standards issues. I'd like to introduce you to my colleague, Peter Adkins.
Hello, as Sarah just said, my name's Peter Adkins. I am also a commercial litigator, but I have also looked after the needs of the CIPHE members for around 10 years through the legal helpline.
So Peter, it'd be good to hear a little bit about Ems Gilmore Libison Solicitors and the sort of work that you carry out.
Thank you, Paul. Ems Gilmore Libison, we're a firm of solicitors, quite a small practice, about 35 people, based in Birmingham, but we carry out work all over the country for our clients, and that is mainly dealing with their business needs, their corporate commercial needs, but as you'll have heard, we also do a range of litigation activities, including looking after actions against the clients, defending and prosecuting those, and also health and safety work. And that is what we're going to focus on mainly today.
Well, Sarah, I believe you've got some scenarios to share with us today from a legal perspective, focusing on our industry.
Yes, that's right, Paul. We've come up with some illustrations, 3 or 4 illustrations that might help to assist some of your members going forward. What I'd like to say at the beginning of this, they are merely illustrations. They can't be relied on as legal advice because each case has to be viewed on its own merits. Obviously, with all scenarios, there are issues that arise, such as liability, which can be difficult to establish, causation, which can be difficult to establish, and of course, who actually is the defendant. When you're looking for someone to commence proceedings against, it is sometimes incumbent upon you to look at insurance, because it may be that somebody within the proceedings is not insured, and that will of course change the outcome of those proceedings.
Just following on from what Sarah said, the CIPHE do of course run a legal helpline which we look after for you, so if you have any doubts and just want a bit of quick advice, you can ring us up and we'll give you up to 15 minutes on no obligation basis. That is the same whether or not you're a simple member out on the tools or you are a big international corporation. The firm deals with many multiple site corporations throughout the country and indeed the world.
So let's dig a little deeper into these scenarios, Sarah. So I have a question for you. It's the first question of about 4. It's a scenario where an installer goes into a consumer's house and fits a branded gas boiler. It's a new system, it's a full heating system, but let's just say he installed it incorrectly. Who is responsible?
Well, Paul, in those circumstances, again, we'd have to look at the merits of the case, and we would have to see if there was a contract in first instance, and there may well be a written contract, or there may well have been a verbal contract between him and the homeowner. But in that instance, the installer would be at fault. It would be his responsibility to rectify any of the defects or problems. So it's a very straightforward scenario in those circumstances. But again, what we would say, and both my colleague Peter would say the same, we would have to see all of the documentation and take any proof of evidence from the installer and or the homeowner.
So facts are critical here.
Absolutely.
Get the facts together, get everything in a chronological order and available for the solicitor to see.
Absolutely.
We are assuming, of course, that there is absolutely nothing wrong with the boiler itself. There's no parts malfunctioning or something like that.
Okay.
It's a properly manufactured boiler, and it's purely the installation that has gone wrong here.
So it's a fit-for-purpose product upon delivery to the consumer?
Yes.
Okay, thank you. So let's move on to a more detailed scenario. So let's say, and this, before I start, this is quite a common scenario. A contractor takes on a subcontractor to install and fit a branded boiler and a full heating system, whether it be in a private homeowner property or for the local authority, tenanted. Let's just say it was not installed correctly. Who is responsible?
Well, Paul, under those circumstances, the contractor has a liability to the local authority. So the local authority will have a recourse against him. The fact that the contractor has taken on a subcontractor, again, does not negate the contractor's liability for any of the acts that the subcontractor may have undertaken or not omitted to do. The difficulty, of course, is that moving forward is that one has to establish where the loss has arisen.
So the subcontractor, does he get away scot-free?
In these circumstances, no, because it's likely that the contractor has got an indemnity claim against him and will be able to bring proceedings against the subcontractor. It would also mean that if the subcontractor is negligent, that the homeowner may also have a claim against him, or i.e. the local authority may have a claim. We have of course all assumed that there is no defect in the product. However, if there had been a defect in the product, it may be that the manufacturer is responsible in some way.
Okay. So my third question's for you, Peter. Same scenario, just a little bit of a difference. This boiler's been in operation now for 3 years, no problems. However, in that third year, suddenly the boiler breaks down. The big issue is, though, it's never been serviced or maintained. So who would be responsible?
Thank you, Paul. This is a very normal situation we get on the helpline. A lot of consumers try to ring up and pass the buck, so to speak, onto the installer. As you've said, this system has worked perfectly adequately for 3 years, so it's very unlikely there's an installation problem. It would be down purely to the maintenance of the system. Now, unless there is a guarantee which goes on for a long period and requires the contractor to maintain it on a regular basis, the obligation for maintenance will be with the consumer. So if the consumer has failed to have it maintained properly, then the buck is going to stop with them, and the installer will be able to walk away from this problem.
Okay, that's a very key point. But my fourth question, I'm going to open this one to the room. The scenario is this: the contractor has been contracted to carry out heating system installations for the local authority. However, that contractor subs it out to another contractor who then installs the systems. The situation is the fluing system has either been installed incorrectly, or there's a fault with the fluing system from a manufacturing perspective. There's a fatality. Somebody dies, who is responsible?
Okay, Paul, that's an interesting question, because obviously it falls within both the civil and criminal liability. Various issues arise. The easiest course of action, of course, for the local authority would be against the contractor, the contractual arrangements which we would again have to look at. And that would be, in first instance, a straightforward claim by them for the cost of repair and installation. However, looking at the scenario in more depth, it's likely that the contractor has an indemnity against the subcontractor. Moving that forward again, if it's established that there's been a defect in the flue system, and that may well have been the whole cistern or a manufacturing component, what would normally happen in a scenario like that is that the health and safety executive would be brought in because of the fatality. The site would be examined and there would be reports generated from that, and it's at that point that you would be able to establish where the liability actually arises. If it is then proven that it is a manufacturing fault, then there are issues that arise from a corporate manslaughter perspective, and in those circumstances there would be a claim against the manufacturer for that. There are also issues, of course, probably that have to be considered under the Consumer Protection Act. But in all circumstances, moving the scenario on further from the homeowner's or the tenant's perspective, they of course then have a right to bring a claim under the Fatal Accidents Act.
So Sarah, you mentioned earlier about the contractor may well have an indemnity claim against the subcontractor. So where does insurance fit in?
Well, again, Paul, that's a very interesting question. It's something that my colleague Peter can explain, because it is obviously very important. I'll pass it over to Peter.
Thanks, Sarah. Insurance here is vital, and it's very important that whatever level you are, the contractor, main contractor, or the actual person such as a local authority, that you sort out the right level of insurance for these kind of cases. On the fatality case we were just talking about, obviously those claims can be very sizable, and if there isn't the right level of insurance in place or the right level of cover, it could collapse the company, it could bring a sole trader to their knees, indeed they could end up being bankrupted. So we have to be very careful here. The insurers should be contacted as soon as possible if there's any idea of a claim, particularly if there's a fatality. They may want to get involved right at the very start. Indeed, it's almost obligatory that they are involved right at the start. Now, insurance will help you out in terms of the civil claim, in other words, the monetary level of it, but they're unlikely to be able to help you out very much with the criminal side of it, although they may pay for a criminal defence on the action. So you really do need to contact them at the right stage. One thing we should say is that the appropriate level of cover is very important, not just in terms of the monetary value of the insurance, but also in terms of the work you carry out. So for instance, if you are insured just simply as a plumber who installs washing machines or dishwashers, and you are installing gas central heating systems, it's very unlikely you've got the right type of insurance. So make certain you've got the right wording on your insurance policy, and then you stand a chance of being covered in the right way.
If I can just add there, one of the most important things, of course, is always to have insurance details checked at the onset of any contract. So before you embark on a local authority contract or any work, make certain that you have got full insurance.
Yes, and I completely empathise with that one.
Yes, there is, if you're handling work for a local authority, they are very often in their contracts specify a minimum level of insurance.
Yes.
And again, if you're not complying with that, then you're in breach of contract and losses flow from that.
And that's quite easily missed, I assume, from the outset as well.
Very much.
Okay.
You can understand the scenario. A company is being approached by a local authority, they're rubbing their hands with glee, thinking this is a nice contract, they miss those elements in the contract, and all of a sudden they're in breach and things are going wrong.
Okay, thank you very much. So I've got a question for you. I assume this could be quite a common scenario. An installer, through maybe lack of training, or he might have been tired, he sits at home one night and he thinks about the job he's installed, and he realises he's done something incorrect, which could cause a fatality. He says to himself, well, on the one side, I don't want to go back to the customer and tell them that I've installed something incorrectly, or I don't want to go back and make the consumer feel they're vulnerable, because if I knock on that door again and ask to go back in the house and do more work, they're going to ask questions. So in their mind, they sit there and they think, what if, or what are the chances of? What would you advise people if they called Ems Gilmore Libison solicitors with that sort of question? What would you advise them?
Well, I think that's an issue that we're faced with, in sort of quite regularly faced with. But the most important thing is that you seek legal advice, because the worst thing that you can actually do is not to go back and rectify the problem. It is absolutely important that you seek advice, because it may well be that by being aware of a problem with the installation, that you void any insurance cover that you have, because sometimes things come from the date of knowledge. So in the worst case scenario, the system explodes and someone is killed. Once there's been a criminal investigation, then you will find that you are completely in line for a prosecution, and you'll have little or no defence to that. And more importantly, you have a moral duty, because if there is an issue that can be easily rectified by a second site visit, then that's something that should be looked at immediately. Okay. But what we would both say in these circumstances, if in doubt, you can ring your solicitors. Everything you say to us is in strictest confidence, and we may well be able to advise you on a clear course of action to rectify a problem and save not only life and limb, but also any losses and any distress that you might be going through yourself.
Because that's what it boils down to, it's protecting the safety and health of the public. So do not forget that you have a responsibility to that consumer and to the public when you carry out any work in their home.
Absolutely. I mean, people are human. We all make mistakes. And if you realise you've done something wrong, you shouldn't be scared to go back and actually try and put it right.
Yes.
You don't necessarily have to explain to the consumer exactly what has happened. Go back, make certain it's right, make certain your insurance remains valid, it's not invalidated.
Yes.
And sort it out, and you'll sleep easier at night.
Okay, thank you. So I'd like to thank Ems Gilmore Libison Solicitors, and more importantly Peter Adkins and Sarah Bingham, for being part of this very first Smart Talk Live on law, focusing on the plumbing and heating industry. So I'd like to thank both of you today for some excellent answers to my questions, and I hope our members will benefit from the advice you've given today.
Thank you, Paul. We look forward to seeing you again soon.
Thank you.
Thank you very much.
The CIPHE would like to thank Ems Gilmore Libison Solicitors today for an excellent Smart Talk Live. The Institute would like to finish off emphasising 3 key points. Number 1, always ensure you are competent and qualified to carry out any work in a consumer's property. Number 2, always ensure you have a valid insurance. And number 3 is, if you enter into a contract, either as a subcontractor or a main contractor, make sure you have your contract checked at the outset before you carry out any work.